The governor, Mark Dayton, based on his submissions to the court, thinks that he and his commissioner of deed, Katie Sieben, substituted for Mark Phillips, have virtually unlimited power to deny emergency unemployment compensation benefits to any applicant because under the 11th Amendment and the Younger abstention, 1, he can never be challenged for Deed's mishandling of federal programs and federal rights because that matter is limited to state proceedings whenever an appeal by an applicant is initiated. 2, neither a bankruptcy court nor a federal court have the power to hold that state accountable for their administration of the program. Now respondents maintain that what is at the heart of their refusal to grant me the rights and protections conferred on me by the 2010 Act is a legal theory that, quote, it does not apply to persons who received federal EUC benefits before its enactment, July 22, 2010, unquote, as I've already described. Abstention of federal jurisdiction under doctrines like and including Younger. But respondents sought to prevent federal review of their mishandling of the federal program and now still seek to shield it by asking the court to hold off on applying the strict mandate to me. Although they offer no substantive argument as to why the Eighth Circuit application of Younger should not be overruled in this case as it has already been. Sprint was very clear, quote, federal courts, it was early and famously said, have no more right to decline exercise of jurisdiction which is given than to usurp that which is not given. That's from Collins versus Virginia, 6 Wheaton, 264 from 1821. Jurisdiction existing, this court has cautioned, is the U.S. Supreme Court. A federal court's obligation to hear and decide is virtually unflagging, citing Colorado River Water Conservation District from 1976. Parallel state proceedings do not detract from that obligation. That's from the Sprint case. Now the courts below have extended the Younger doctrine to a proceeding, ULJ phone discussions with an applicant deprived of his weekly EUC benefits, a phone conference with no parties, not even the state as a party, a phone conference initiated by me, not respondents, for the purpose of challenging the deprivation, which had begun months earlier with no notice or opportunity to be heard pre-deprivation. It was remedial, not coercive, and it was not calculated to make my payments when due, or to preserve my due process rights before losing those payments, resulting in $0 per week payments indefinitely. Now, respondents disingenuously pretend that I initiated the hearing because I challenged the determination that I was eligible to receive state benefits. That's clearly false. I believe I was eligible to receive state benefits, and that eligibility was requisite for receiving continued payments of my remaining entitlements. So here's the ULJ. The issue of why the Act does not apply to me has always been a mystery, and the response contains the latest version. Respondents do not dispute the accuracy of the transcript of the ULJ hearing on the first state account, which together with a statutory summary review by the Minnesota Court of Appeals, they call Carlson 1. In that transcript at page 7, the ULJ says, okay, all right, so why don't you explain to me then what it is you're appealing? To which I answer, I was getting benefits because of the loss of full-time employment, that right now I'm taking 0. And so I think that I would like to appeal that and to have the benefits of the U.S. Congressional Act apply to me. And I think that the way the state is handling my particular case actually violates the statute and some of my constitutionally protected right. The ULJ responds, the statute provides for pay of emergency unemployment compensation benefits and is only if an individual is not eligible to receive regular state benefits. I ask, now which statute are we referring to here? The ULJ says, the federal statute. And I say, okay, could you and this from what year and what are you looking at? Because I filed this so you would have it. The ULJ, which one? It's unintelligible. Which provision are you referring to? I say, all right, I'm looking at the Restoration of Emergency Unemployment Compensation Act of 2010. Is that what you're looking at? The ULJ, what's the statutory citation? And then he says, the statute you're referring to is only applicable until federal legislation was passed, which was effective July 24th, 2010. I say, right. And I came in on, and as you say, like September 12th, so it was after that day. ULJ, I understand it was after that date, so therefore that provision of the Minnesota statutes is not applicable. And I say, well, the Minnesota might not be, but the federal statute is certainly applicable to me. And it's very clear as to what the state has to do to be eligible for this program. The ULJ, okay. They say, it says, under G, coordination of emergency unemployment compensation with regular compensation. And I proceed to read to the ULJ what the coordination provisions, subsection G, say. And as I said, I brought a copy of that statute to the deed office to put on the record of the hearing. And the ULJ and deed improperly excluded it. And that's something we discussed right in the hearing on the transcript. And he ruled it wasn't applicable to me. Okay. So this is what actually happened. And where there were no parties, and it's just this guy telling me his opinion of a statute that he doesn't even see, apparently, because that's what he's been told to say. And he's supposed to be a judge. Now in that hearing, as the transcript shows, the ULJ said the act didn't apply to me, he thought, because the state law only applied to me until the federal law was passed July 24th, 2010, apparently the act that I'm referring to. I argued that yes, if the state law no longer applied, I believe he was referring to the law that wouldn't let my payments go beneath 80% of what I got, it was a state law, and saying that that would be superseded by the federal act. Now certainly, and I said that certainly the federal act applied, and I proceeded to read the act to him. He indicated he didn't know what I was talking about. He had excluded the act that I walked into the deed office from the record. He was going to go get the act and find out what it said and let me know. How is this an opportunity to litigate anything? No parties, just a fact-finding hearing, purportedly a challenge to my entitlement for state benefits, which it was not. This was months after respondents cut me off, and there's a strong possibility based on these antics that deed was frantically trying to justify what it did to me while I was running for federal office. Otherwise, it's, with all due respect, farcical. That the district court would say it won't review, it is bound by this kind of proceeding, is amazing. It can't be res judicata because there are no parties. Carlson, too, had the Census Bureau as a party. Not until I get to bankruptcy court is there a party, respondents. Respondents were not the parties in Carlson 1 and Carlson 2, as they name it, and the Minnesota appeals courts just proceeded on a statutory writ and provided no more due process, no more parties. So this proceeding cannot be this one that the court says excludes federal jurisdiction. In Sprint, this court reaffirmed New Orleans Public Service Incorporated NOPSI. There is no in which they held there is no doctrine that the availability or even the pendency of state judicial proceedings excludes the federal courts. Now what this means is even if there's something you could do in the state court but you have a federal question which specifically empowers the federal courts, which were established by Congress under Article 3 of the Constitution to hear, that cannot be excluded because the state comes up with a proceeding when it's in this kind of case where it's a federal program and you have federal constitutional rights. They cannot step in and violate your rights under any pretext and not be reviewed by the federal government. Some might say I state that too strongly, but that's how I read what they just ruled in NOPSI. Even the pendency means that it's ongoing, and availability means there's a process that, like for instance in my case, I could have gone to the Supreme Court and it's available to me, but it doesn't, according to NOPSI, exclude federal jurisdiction. Now the unanimous opinion held that Younger extends to the 3 exceptional circumstances accepted in NOPSI, but no further. And so what are these circumstances? First, Younger precluded federal intrusion into ongoing state criminal prosecutions. Second, certain civil enforcement proceedings warranted abstention. Finally, federal courts refrained from interfering with pending civil proceedings involving certain orders, uniquely in furtherance of the state court's ability to perform their judicial functions. So a ULJ talking to me on the phone, telling me he doesn't know what the law says, but he's going to find out and let me know, this is not one of those special ability to perform judicial functions. He's not even a judge. So it's not excluded, and I'm asking the court to agree in accord with their sprint that the younger doctrine must fall in this case, and we can be protected from interference in the state, by the state in federal programs for our benefit. Now, respondents have extended younger much further where no exceptional circumstances existed, and the district court deferred in an egregious abuse of discretion and contrary to law. The 8th Circuit panel treated me far worse than they treated Sprint, simply concluding that see also Middlesex extending younger to ongoing state civil proceedings. Now, compare this with the more nuanced version in Sprint. Abstention is appropriate, quote, whenever an ongoing state judicial proceeding implicates important state interests and the state proceedings provide adequate opportunity to raise federal challenges. Compare the important state interest in regulating and taxing telephone companies in Iowa versus Minnesota deciding by a ULJ phone hearing whether the act applied to me and to give me my entitlements. Further, the only adequate opportunity to raise my federal questions would have been in a pre-deprivation notice and opportunity to be heard. So the younger doctrine was not uniformly applied in the circuit, in the 8th Circuit, and there was and is a conflict with sister circuits. For example, Circuit 1 said abstention was appropriate only when parallel state proceedings are coercive, which mine was not. It was remedial. Now, this clearly contradicted the court's 1989 decision. Long-standing, this happened decades ago in NOPSI, that, quote, there is no doctrine that the availability or even the pendency of state judicial proceedings excludes the federal courts. And this was on a remedial emergency matter that predictably pushed me into bankruptcy. Respondents say the law does not apply to me, but equal protection of the law and due process requires it does. While I did not use Sprint as the basis of my petition, I did use Younger and pointed out how the respondents violated Younger as interpreted by this court. Secondly, the proceedings at Deed, the ULJs, reviewed summarily by a statutory writ by the appeals court, was entirely contrived. Deed continued to violate the law in the appeals court, and while plain language was relied on by Judge Stoneburner in the key appeal decision, it was illegally decided on moot. As such, there were no issues litigated repeatedly. There was no overlap at all between the parties and the proceedings. Respondents depict as precluding federal review by issue preclusion, and there can be no claim preclusion, res judicata, without issue preclusion, or there was none in this case. Further, it is a plain contradiction to say state proceedings were ongoing at the time of the federal suit, but at the same time they had already reached a binding decision that must be accepted by the federal government. You can't have both.